Thank you very much for your thinking this reflection on how can justice evolve in the future, the dilemmas we are facing with it. And I remember that we are now in the segment of this high-level conference about digital transformation in justice today and tomorrow. We need to restore trust in justice at the same time that we take advantage of everything that the pandemic crisis brought to the sense and the need for justice all around Europe and all around the world. Now we move to welcome the President of the European Commission for the Efficiency of Justice, Ramin Garagurbanli, that will share a presentation on the way, I hope I pronounced your name correctly, that will share a presentation, I was saying, on the way a people-centered justice can be used to improve efficiency. That was something that was mentioned just a few minutes ago. Good morning.
I would like to thank you for the floor. First of all, I would like also to thank the organizers for such an important event and express my deep appreciation for the invitation. I'm representing today the European Commission for Efficiency of Justice of the Council of Europe. And the topic of my speech will be related to the justice efficiency and on metrics for people-centered justice. I would like to say that the central place of court users in the realization of the Council of Europe strategic objectives on efficiency and quality of justice is an established fact within this organization and inspires in a transverse way the work of the CEPEJ. Admittedly, the quality of justice is one of the core enablers of the rule of law and an essential guarantee for the sustainability of the democracy-based institutions in the Council of Europe member states. But it's above all an individual right enshrined in Article 6 of the European Convention on Human Rights, even in the era of digitalization. We should acknowledge that the eJustice system should be capable of resolving issues without creating the obstacles for users and be closer to them. Court users constitute one of the common denominators of the CEPEJ endeavors to accompany member states in their national strategies in the justice field and to construe the existing European standards from the user's perspective. Set aside the fundamental principles of independence, impartiality, and integrity, the main requirements of citizens on the judicial system in the era of digitalization can be summarized as following. First expectation is related to the accessibility of justice. On the one hand, and having as a starting point the member states' obligation constantly recalled by the European Court to establish effective domestic remedies based on Article 5, 6, and 13 of the European Convention, and the stemming individual right to access a court, the CEPEJ was able to address very specific and preliminary issues to this fundamental rights through its guidelines on creation of judicial maps and its guidelines on the organization and accessibility of court premises. Taking into account the user's expectations, these two documents offer concrete solutions for policymakers to improve access to justice, efficiency, and performance of court, access to information, and etc. On the other hand, the justice should be accessible to all citizens in its essence, which led the CEPEJ to think about ways to improve communication between courts and recipients. In fact, the Commission is currently preparing guidelines on the issue of simplification and clarification of language with litigants, particularly in the drafting and communication phase of judicial decisions, and the simplification of legal language is an essential element of the more general objective to bring justice closer to citizens and to make it more transparent and accessible. In addition, effective access to justice also relies on effective legal aid system, and the importance of this section dedicated to this topic in the CEPEJ biannual evaluation report grows from cycle to cycle, analyzing the evaluation of the legal aid budget in member states, the eligibility conditions to benefit from legal aid, and etc. Finally, the CEPEJ analyzes regularly how the use of information technologies in courts facilitates the access to justice, namely through the existence of centralized national database of court decisions, the possibility to submit a case to courts or request the legal aid by electronic means. The second expectation, this is the promptness of justice against the background of the voluminous case law of the European Court of Human Rights on the requirement of reasonable length of proceedings. The CEPEJ has developed numerous legal instruments, tools, and studies to orient policymakers and judicial practitioners when reforming the normative frameworks towards optimum and foreseeable timeframes of judicial proceedings. It's noteworthy referring to the guidelines for judicial time management, providing a list of possible actions to be undertaken to fight the excessive length of judicial proceedings, and the implementation guide named towards European timeframes for judicial proceedings. In the wake of these basic documents, a specific study has been recently conceived on case weighting in judicial system, analyzing the different case weighting systems that assess the amount of time and effort each case requires to be processed on average. And the final goal here is to achieve prompt and efficient justice through a balanced and transparent distribution of cases among judges, while the final beneficiary is the court user. Generally, the CEPEJ is aware that the concept of reasonable time and the requirement from promptness extends well beyond the sole court proceedings, from pre-trial stages to enforcement of judgments. But it's also aware that all actors intervening on the justice scene are bound by the time imperative. Therefore, currently the CEPEJ Saturn Working Group is preparing several guidelines on the respect of reasonable time by court staff, experts appointed by court, lawyers, enforcement agents, as well as guidelines for red flaggers on prevention of delays in judicial proceedings. Finally, the development of new information and communication technologies contributes to reduce the judicial time. And the CEPEJ is interested in the existence of voice recording tools in court, writing assistance tools for judges, dematerialized communication between courts and lawyers and other parties, online processing systems of specialized litigation, and etc. Besides the regular data collected for the evaluation report, the newly established CEPEJ Working Group on Cyber Justice and Artificial Intelligence has already prepared analytical overviews of the state of play in electronic court filing, e-filing, online alternative dispute resolution, and in other fields of e-justice. The third expectation, this is the efficiency of justice, as defined in the CEPEJ evaluation report. Efficiency of courts and public prosecution services is a vital factor for upholding the rule of law and a critical component of a fair trial. It facilitates good governance, promotes the fight against corruption, builds confidence in institutions, and enables individuals to enjoy effectively their fundamental rights. And the CEPEJ is analyzing court performance through specific indicators, such as the clearance rate and disposition time, measuring at the same time their capacity to solve cases without creating backlogs and the theoretical time necessary for a pending case to be resolved. The CEPEJ measures court performance, but also proposes concrete solutions for improving their efficiency. For example, how handbook on court dashboard is currently under preparation, and it's intended to assist stakeholders in court systems in the task of designing e-management dashboards to track analyze and display data on the performance level of the courts. Also, efficiency means a specific approach for specific categories of court users. And in this respect, the CEPEJ collects data on special favorable arrangements to be applied during the judicial proceedings to certain categories of vulnerable persons, such as victims of sexual violence, terrorism, domestic violence, human trafficking, ethnic minorities, and persons with disabilities. Besides that, court users expect that their case is dealt with an independent, impartial, but also competent judge. And in this field, also the Commission adopted the guidelines to improve the judge's skills, competences, strengthen knowledge sharing and collaboration, and move beyond a culture of judicial isolation. And this document contains guidelines and principles aimed at presenting tools and means that could improve the judges' work, especially by enriching their knowledge, but also by contributing to their well-being at work. At the same time, the court users are, in their turn, responsible for the efficiency of justice and for the quality as well. And CEPEJ carried out recent analysis on the role of parties and practitioners in avoiding and reducing delay in disposal of court proceedings, and is working now on the documents named Putting the User at the Center of the Legal Proceeding in Civil Matters. We should acknowledge that the surveys reflecting the perception and the expectations of the court users, including judges and other members of the other parties, are inevitable indicator of efficiency and guide for future reforms. In this regard, CEPEJ handbook for conducting satisfaction surveys aimed at court users in the Council of Europe member states is a very useful and essential tool. Finally, and most obviously, the contribution of ICT in terms of efficiency of justice is also undeniable. Accordingly, the CEPEJ is closely following through its evaluation report the development in member states on case management systems in courts, e-measurement tools to assess the workload of judges, prosecutors and judicial staff, e-tools facilitating the communication and the materialized exchange of information within the judiciary. And a special chapter is dedicated to the ICT in judiciary, given that the good development and proper use of ICT is an important element of the good functioning of judicial system, as it contributes to the increased transparency, efficiency, access, and the quality of services delivered. The first and the last expectation, this is a predictability of the justice. Among the main users' expectations are these concerning the predictability of the time frames and costs of judicial proceedings. The CEPEJ collects data on the existence of an obligation to provide information to the parties concerning the foreseeable time frames of their proceedings, as well as on the existence of the prior information on the foreseeable amount of lawyers' fees or rules on lawyers' fees. Since a few years, court users also have the other very significant expectation, as it was mentioned by the other speakers, concerning the predictability of the judgment of the application of law. And the CEPEJ contribution in this regard is of paramount importance and goes beyond the European borders. Nowadays, the European Ethical Charter on the use of artificial intelligence in judicial systems and the environment has acquired the status of inevitable reference in matters of the use of AI in the justice field. The use of such tools and services in the judicial systems seeks to improve the efficiency and quality of justice, but the respect of human rights stemming from the European Convention and the Council of Europe Convention on the Protection of Personal Data is an imperative reserved to this use. The Charter emphasizes that whether designed with the aim of assisting in the provision of legal advice, helping in drafting or in decision-making process, or advising the user, it's essential that processing is carried out with transparency, impartiality, and equity, but under under user control, meaning that users must be informed actors and in control of the choices made. Moving towards cyber justice system is a reality that the CEPEJ takes into account in its guidelines on how to drive change towards cyber justice. The Commission admits the role of ICT tools in improving the performance, the efficiency, the promptness of judicial systems in terms of access to justice, delivering of justice, providing the transparency, communication between courts and with professionals, assistance for judges, prosecutors, and judicial staff and court administration. However, above all, it insists on the fact that the deployment of digital tools of cyber justice should take into account of both the requirement to guarantee higher quality standards for the public justice service and of the expectations and needs of justice system professionals and users. The current works of the CEPEJ all go in the direction of justice centered on the user, and CEPEJ in particular, through its evaluation reports, deals with the organization, the functioning, and the performance of the public service of justice, including eJustice, for the benefit of the public, of the user, even of the client, as we say in the Anglo-Saxon countries. Additionally, I would like to finalize my speech. The advancements in the researches, analysis, and concrete results in respect of judicial timeframes, cyber justice, ICT, and artificial intelligence in the justice field have as a common dominator the focus on the court users and the awareness that the latter are not only beneficiaries, but also contributors to the achievements of the strategic goals of an efficient justice system. I would like to thank for your attention and again for the invitation to participate in this important event. Thank you.